to them.
So without telling us anything else that anyone else said, it was your understanding at that time that she was not trying to return to the agency, correct? Okay. And you called the police again, according to respondent 8 on August 13th. Not the military time. But later that afternoon.
Yes, when that was the same day, when I went in the morning, I called the police, and the Connecticut County Police responded back to me. The officer called me and they said, oh, they were aware of what happened the day before, and the officer said at this point what I need to do is to write a 10-day demand letter and to serve out the letter. Then after 10 days, then they can kind of file the criminal charges against her. So I went back to my office, I drafted the letter. When I had time in the afternoon, I think around 3. So I went back there. That's when I went to. So I made 2 copies. I dropped one under the mat, and I threw the garage was open like halfway, and I dropped one through the garage. I'm happy to be of those 2 copies.
So you reported yourself on August 13th, placing a copy of the Sunday letter under the front door mat.
Yes.
And placing a copy under the garage door that was slightly open.
Yes.
And do you have that video with you right now?
Yes.
Okay. And Your Honor, if you'll let me know how you would like to, Mr. Constable, see the video.
How is the video marked for identification purposes?
It will be marked R20.
R20. And any objection to the video?
I'd like to see it. No objection. I'd like to see it again, though.
Okay, so no
It's
objection.
30 seconds long. No objection to it in it.
Minute. Did you bring, you don't have your laptop, that's what I said, do you want to play
I
it
don't
on a
have-
laptop or do you want to play it on his cell phone?
I did not bring my laptop today. I do have it on a thumb drive if the court would prefer it be shown elsewhere.
We have no way of showing it, so,
So then we will pass it on to Mr. Casco if the court will allow
I
it.
was gonna say, well, I'll have, counsel come up here and that way we can all watch it together.
So I'm not going to object to that if I'm extending the same courtesy for cross-examination of showing pictures on my phone.
Can you say it again, sorry?
I'm not going to object to this procedure if I'm allowed, extended the same courtesy, allowed to show photos on my phone and ask questions about them.
Sure, I'm actually not using my phone, I'm using my client's phone. So
Well, like a phone.
A phone. I'm not sure that works.
Not a problem.
Alright, so if, you can pull the video, okay, the counsel, I have counsel come up this way, just so I'm able to see it and they're able to see it.
There's actually 2 videos on our forgot to get there. There's actually 2.
I've only seen one. Yeah, I've only seen one.
Well, and hold on then, let's pause for a second. Are they labeled separately?
They are labeled.
What is, I was gonna say, so we need to see the second.
Yeah, I
Mr.
haven't seen it.
Let's do this, let's take 5 minutes, I'm gonna allow him to watch the second video, and if any other evidence the parties may have, and they're gonna wish to hear, I'm gonna have you go ahead, show each other that, so
Absolutely.
that we're streamlining the process, and I will return in about 5 minutes.
Thank you.
Thank you.
Hey, you what, sitting at 5, you can get food at 4:30. Or 1 o'clock. Also, I think the CB23 is in P4, it's already there for the second.
Okay, put a 1 in the chat if you hear the sound of my voice.
Those 3 calls all the same day? Those 3 calls are all the same day, the 13th?
It was 1 on the 12th and 2 on the 13th.
All right, thank you guys. Thank you. I'm in court covering a very important hearing right now. Thank you, everyone who's been checking up on me. I appreciate that. I really do. We're just waiting for the judge. Cameras will be up in a minute, guys. Stand by. About 1 more minute. I think the judge will be back on the bench. Stand by. Stand by. Stand by. I'm about to turn the camera around. Just
Remain seated, be in order.
She's outside. She just. No problem. I have, Your Honor, we're gonna stipulate to admissibility.
All right, and the second video for identification purposes is labeled as R21. Okay. If you wish counsel, if it will come up, please. All right, this is R21.
He's the accused. The woman beat her, but he contends that she is only doing this to get a car. Using
Can we see the whole video with all the sound, please, for complete? It's the first thing you showed me with the two different. No, that's the video where you say he's not leaving. That you showed me earlier. You have a video on that?
that's the IG model.
Now I'm confused, because that first video you showed me, you said I'm not leaving. I don't know if these are the same ones.
All right, I've seen the video, so we can turn the phone off now, and I'm going to have instructions. I'll let the deputy hold on to it to the conclusion of the hearing, or if you would like it placed on the table out of reach of parties. Thank you.
All right. So, Mr. Fatai, how were you served with notice of this action?
The sheriff came to my job. I was actually, that's when after the letter, 10-day demand, I spoke to the officer, and the officer, when I called, I also called the commander and police just to let them know that I've done what they asked me to do, and then the officer told me that, because I still have my credit card with her, the fuel card, and my dealer's card. And then the officer said, maybe she can try to retrieve those.
And don't tell me what the officer
Oh, okay.
said, but Ms. Carlson, as far as the service of this TPO, what is the relevance?
I believe that because Mr. Fatai was served on the last time that he called the police on this call.
Well, and the court does have, and it is a matter of record, the sheriff's entry of service.
Understood, Your Honor. So, Mr. Fatai, you said he was not received the vehicle back.
Yeah.
And you wish to receive the vehicle.
Counsel, what does the vehicle have to do with the TPO at this point?
Your Honor, I struggle to think that it's not the reason we're here today. It was included in the ex parte order. She was given primary use of possession of a vehicle that she does not own. And he still does not ask for that. And I understand that is not something the court is going to address today, but it was addressed in the ex parte.
Dun.
You can continue. Thank you, Your Honor. I don't want to get much into this. I do see with the car was addressed in the ex parte. But please keep in mind, the court is here just to determine three things.
I understand, Your Honor. And I will ask just a few more questions. Mr. Fatai, did you visit Ms. Carvalho's home after August 13th?
No.
At no point in time?
No.
Have you had anyone visit her home on your behalf?
No.
Have you had anyone contact her on your behalf?
No.
Has anyone followed her on your behalf?
No.
And you are asking the court today to order the attorney's fees provided within this action, correct?
Yes.
Your Honor, I will save that for closing. I have no further questions from Mr. Fatai right now.
request for attorney's fees?
We did not know.
Cross-examination.
Thank you. Mr. Fatai, you said you were served the protective order at your lot on August 13th
No, this happened at home.
at home. Okay, at what time?
It should be around like 8 or 9, 8 p.m.
At night?
Yes.
Okay. And then, when were you over at Ms. Carvalho's house on the 13th?
I was there around 3 p.m.
And you weren't there later that night?
No.
Okay, all right. Now, so you testified that you never lived with Ms. Carvalho, correct?
Yes, that's right.
Now, but you did sign a lease with her on August 2nd, 2023, right?
I signed a lease, like I stated earlier, my testimony that she had no, we just spread out the place to live, I get the house, the apartment on my name for her to live.
So you signed a lease with her because she's your friend.
Yes, we just met that time.
Oh, better yet. You signed a lease with her as a friend you just met.
Well, not as a friend, I just met.
You just testified.
Yeah, we just met not too long at the time when she was having her issues, she doesn't have a place to live. I signed a lease with myself alone, but because she's gonna be living there, I added her to the lease. The property said we can add it, she can be added to the lease, that's why she added to
So y'all were just friends till October,
the lease. Yes.
but this a real good friend apparently, so you signed a lease with her on August 2nd.
Yeah, well, friend was one of the days, but we didn't start dating until October.
Oh. Is that something you typically do, rent apartments with friends and get on their lease?
No,
No? Okay, just this friend,
yeah, because I'm interested in her, so that is.
but y'all weren't dating?
We were just getting to each other at the time until we started the relationship.
And y'all were talking about a blended family, because you both have kids, and being a blended family, right?
We wasn't talking about that at the time. We were not.
So how about it all, from August 2nd to next year in August, when that lease was in effect? Did y'all talk about it at all then? And did you ever sleep at that apartment one time?
No,
Never.
never.
So no one would have seen you there at that apartment?
No, I've been there. I visited the apartment for a couple of hours.
Just visiting a friend, right?
No, we were after she moved into the apartment. I think around October we started a relationship. But we were just going on a date, get to know each other. But we didn't start a relationship until around October.
So none of those text messages, there's nothing talking about commuting, going back and forth, anything like that?
Which text message?
Those text messages that your lawyer admitted?
We were already in a relationship. The text messages are recent. The text message is just a few weeks ago. We were already in a relationship at that. I'm talking about the 2023 when we just met.
So, on the 12th, my client told me she would block you, didn't she? In those text messages. She said, I'll block you. One more smart comment. Your lawyer showed it to me.
Yeah,
Did you
she
see that?
said on the text message that because on that day she was asking for $2,000. She said, "Can you give me $2,000?" I said, "No, I'm not giving you $2,000." Even though I already told her I don't want the relationship anymore, she was demanding to give her $2,000. I said no.
So when did you tell her you don't want the relationship anymore?
That was on Saturday, I believe, August the 9th. I sent her the message and I said I decided better and that's it.
So you changed your mind again, didn't you, and decided you were gonna ask her for a favor the next day, put gas in one of your properties in her name, after you broke up with her and had no further need for her, right?
No, that request was way before the August the 10th. That request for her to put the gas on my property.
That was actually on August 7th, right?
Yeah, the conversation about we broke up was August the 10th.
So your lawyer showed me a video earlier, you stated you were talking to the police, you said, I'm not leaving. Do you remember saying that? I'm not leaving until I get my property?
No, I didn't.
You didn't say that? On that video that I was showed earlier, that wasn't admitted, you didn't say that?
Video, I made the video, I wasn't talking to the police when I made the video. I can't be talking to the police and also make the video.
What did you tell her? I'm not leaving until I get my stuff?
I didn't even talk to her, she blocked me, I didn't talk to her.
So who are you talking to on the phone?
No, I'm just recording, I'm recording, voice the voice message as an evidence that I'm starting now, just say, I'm starting you this letter of 10 days demand, and I struck one letter through the garage, because the garage is open, and I left the other one on the floor mat, and I left. That's what I
Any idea when that video was showed to me, I agreed to it, it wasn't later admitted? Any idea why?
Which video are you talking
The one where you said, I'm not leaving until I get my property?
I didn't have any video that I recorded, and I said I'm not leaving until I have it.
So she just didn't get your property to you quickly enough, right? She didn't drop everything she was doing and get your property to you on your timeline, so that's what upset you, right?
That is not correct.
Okay. So you called the police once on the 12th, and did you do what they told you as far as getting your property back?
On the 12th, when I called the police, the officer actually waited for her about 1 hour. When she came back from where she went, she actually gave me the property. They demanded her that they talked to her, she went inside. At first she said, oh, I lost my key, I don't know how to get inside. The officer told her that, hey, no, we're gonna have to find a way to open the car, open your house for you. And they opened the house, I don't have, because I was standing outside. Then she came out, she gave the item to me, which is my key to my house, my children's clothes, and my mail, piece of mail that I've been waiting for days. And then the officer asked her about where's the car. And she said, oh, the car is at the shop. Then she provided the address, the name of the shop, to us for me to go get the car the next day.
So why did you call the police the second time?
When I called the shop, because I was getting ready to go to the car, to go pick up my car, then I'm just like, let me just call the shop first, so I didn't have problem. So when I called the shop, that's when they told me that the car's not there. Then I texted her, I said, I just called the shop and they told me that the car was there. He said the car's not there. She didn't respond to the message. And that's when I went to her house. When I went to her house, and I called
The second time?
on the 13th.
Okay. So that's the second time in 3 days you called the police on the 13th?
Yeah, the second time is okay.
Okay. And did you do what they told you to do?
I did.
Okay, so why'd you call them the third time?
No, okay, when I called the police on the first time in the morning, I informed them because then she told in front of the police that the car is at the shop. I called the police, hoping that I'm going to be able to talk to the same officer that came on the 12th, and they were informed that the officer is off at the time, but they're going to send another officer to me. Then the officer called me and said, is that aware of everything? And then they said that this, I said, well, I already called the shop, they said the car is not there, so what am I going to do now? The officer said, okay, at this point, what we need to do for us to get involved, we need to give her 10 days notice. Then after that 10 days, then we can do something. Then that's when I left,
So they told you to do the 10-day notice on what day?
on the 13th,
At what time?
in the morning, around 10.
Okay. So that was your second call? Or your
No,
third?
the second.
Okay. So why'd you call a third time?
So the third time when I left, I went to my office, I dropped the letter. The officer said I can just go online and find the letters online. I did find the letter online, I dropped the letter, I went back to the house to drop the letter. And I called again, just to have the record that the letter at the start, and I also made the video about this time at the time that I started the letter.
So, when you were out there on the 13th, again, I'm going to ask you a question about a video that I was shown that was not tendered. That video that was not tendered, you had in that video you had a black copy of this letter. Oh, may I see that exhibit, Judge? My district 22, thank you. So, you had both of these letters with you that day. Do you recall that?
Yes,
Okay. So, which one did you leave on the 13th?
both,
Both of them?
yes.
Okay, all right. Just give me one moment, Judge, please. So you're denying hitting her and spitting in her face on the 13th?
The only time we had, was on the 12th. I didn't see her on the 13th. There was nobody yelled at each other, there was no fighting, there was nothing. We were just going back and forth. And if that never happened, she would have called the police when the police came on the 12th. I called the police. She would have informed the police. There was never, nothing happened. She didn't hit me, I didn't hit her, nothing happened.
And you weren't there on the 27th, and no one drove you, you had your truck on that day?
No, I didn't go, I never been to a house.
Did you have your truck on that day, or was someone else driving your
No,
truck?
that's not true. I never been to a house from.
So, did you have your truck on the 27th, or was someone else
I
driving your
was
truck?
not there, my truck was not there.
Can you answer the question, sir? Did you have your truck on the 27th of
No,
August?
I did not have my truck.
Who had it?
Nobody, I have my truck, but me, I
You
was
just-
driving my truck.
Okay, you can't have it and not have it, sir. Did you have possession of your truck the entire day of August 27th?
Yes,
Okay, no one else had it, is my
yes.
question. Okay, thank you. That's all I have, Your Honor.
Redirect?
No, Your Honor, thank you.
Any further testimony or evidence from the respondent?
No, Your Honor.
Any rebuttal?
No, Your Honor.
All right, then the evidence is closed. Argument,
I'll reserve.
Ms. Carlson?
Your petitioner testified that Mr. Fatai was at her home on the evening of August 12th, with her permission. She testified to nothing further that occurred between the 12th and the 13th when she filed this action, that made me believe that she is actually in need of any type of protection from Mr. Fatai. That's all. Thank you.
Mr. Savoy?
Judge, my client testified that she was physically abused by this individual multiple times, the first time a year prior in another country. But most importantly, on August 12th, she was slapped, she was spit on, and most troubling is, as you heard my client testify, the petitioner's truck was in her driveway on August 27th. She didn't see the petitioner the respondent that day, the respondent's truck was in her driveway on August 27th. She didn't see him, but she told you that she saw his truck, and then shortly thereafter, at the front door, she saw another copy of that demand for the vehicle. That right there, to me, is the most troubling, Judge, that he showed up after the protective order was issued. He testified he had complete possession of his truck that day. No one else was driving his truck. We would ask that you find he is not only, we ask that you find there's a protective order based on the fact that he violated the ex parte order, and I believe my client's testimony sets forth the act of domestic violence in accordance with the statute. So we're asking for 12-month order.
All right. As counsel is well aware, before the court can issue a protective order, the court has to find three things. First, the court must find that there's a qualified Carvalho testified that the parties lived together for a period of time. Mr. Fatai has denied that they lived together. He does admit that he signed a lease. Ms. Carvalho was added to the lease. No lease was tendered to show whether or not the lease was initially entered in Mr. Fatai's name or Ms. Carvalho was added to it. The court heard very little testimony as it relates to the parties actually residing together. It appears from the testimony that the parties agreed that they were in a relationship for a period of time. Again, the court heard very little evidence related to that relationship, but it appeared to go on for a period of time. Both parties referred to it as a relationship. Mr. Fatai did indicate that they started dating in October of 2023, so the court finds that there is a qualifying relationship. Next, the court must find that there has been an act of family violence. The court heard testimony about an incident out of the country in July of 2023. There's no testimony as it relates to any type of injury or law enforcement involvement in the parties. Returned and maintained their relationship for a period of time. There was some testimony related to a threat, though the time frame is very unclear. And finally, where the testimony seemed to, there was this, Carvalho testified 4 to 5 weeks ago, again, with no real time frame about an incident where she was held for an unknown period of time and then ultimately allowed to leave the residence. And very little testimony was provided as it relates to this incident. The final incident denied by Mr. Fatai and testified to by Ms. Carvalho was the incident on the 12th. And the court notes that the police were in fact called, and a call for service was admitted without any objection. That call for service notes that Mr. Fatai went to pick up his belongings, that Ms. Carvalho was refusing to provide those things, and that she left the residence. The officers did speak with her according to this call for service, and she was going to return. But the court has heard no testimony that this incident was reported to law enforcement, that any actions were taken, or that any injuries were incurred as a result. The third thing the court has to find is that an act of family violence is likely to occur if the court does not grant this order. And from the testimony that's been provided today, while these incidents, all of these incidents occurred in the past, there was a great deal of testimony about August 13th. Ms. Carvalho applied for the protective order. Mr. Fatai was served with it. He was at the residence earlier that day. As the court noted, as part of the record, the sheriff's entry of service shows that the petition or ex parte order was not served until 8:45 p.m. The videos that the court was shown that were admitted without any objection showed him at the residence earlier that day, somewhere around 3 p.m. And the two videos show Mr. Fatai leaving a copy of a letter at the garage door and another underneath the mat. Ms. Carvalho testified that she did not see the respondent on the 27th. She found the letter under the mat, which appears to have been left there at an earlier point in time. What the court heard the most testimony about is the vehicle. The vehicle seems to be the point of contention between these two parties. All other items appear to have been exchanged. There doesn't appear to be any relationship going forward. The parties agreed that they broke up. And the contact seems to be centered around the vehicle, both parties wishing to maintain possession. Taking into consideration all of the testimony and evidence that was presented here today, and keeping in mind that Ms. Carvalho bears the burden of proving each of the three factors that the court has listed earlier, the court finds insufficient evidence for the court to find that an act of family violence is likely to occur moving forward if the court does not grant the protective order as the parties have ended their relationship. And therefore the court is going to deny the protective order. Certainly, the parties have made it known that they don't wish any contact with one another, and both should respect that and have no contact with the other party. Any contact moving forward may subject that person to future action. Certainly, if anybody feels afraid or in danger, they should call police for services and assistance. And naturally, as the occasion arises, this does not prohibit anyone from filing a protective order again if the need should arise. With the court finding based upon the testimony that the petitioner has failed to meet her burden, I am assigning a dismissal, and that will conclude the case.
Thank you.
It's $38 each for the and if you have, if you'd like to have cash, that would be great to go, sale or cash.
38 total.
You should.
Good seeing you. Take care.
If you'll hang out, I'll have to take you to get a copy of the order before you leave.
Perfect.
I'll meet y'all down at the clerk's office out front.
Thank you.
All right, guys, I'm ending this live. That's all, folks.